critically speaking, with me, Tarun Nangia. Today, we're going to discuss a few crucial issues on the issue of intellectual property law that have been referred to a larger bench of the Delhi High Court. And this being in the case of Abro Sports International versus Ashish Bansal, raising the fundamental questions about the rights of registered trademark proprietors and the scope of infringement under the actions under the Trademark Act. And at the heart of this critical issue lies that can a proprietor of a registered trademark be restrained from using its own registered trademark, and under what circumstances can court grant interim injunctions when the validity of registration itself is under question. I'm going to request first Kangan to do an explainer, but let me introduce you my panel today. Senior Advocate Chandar Lal joins us today on the panel. He's a renowned name in the field of IP law and as a larger than life personality aside of the law. Good to see you, and thank you so much for your time. I have with me Senior Advocate Sanjay Jain, who joins us. We all know he served as the Additional Solicitor General for India for the past around 10 years or so. Now he's back to punching as a defense counsel at the Supreme Court and other forums. Good to see you, Mr. Jain. Thank you for your time. I have with me Senior Advocate Arvind Verma, who joins me, who practices at the Supreme Court, the Delhi High Court, and other forums. Also does quite a bit of work in the intellectual property space. Good to see you, Mr. Verma. Thank you for your time. We also have two people who work extensively in the field of intellectual property, namely Advocate Kangan Roda and Advocate Arushi Singh. Good to see all of you. Thank you for your time. May I request at the outset that if Kangan, if you can do an explainer and then we start. Over to you, Kangan, for the explainer.
Thank you so much, Tarun, and it's always a great pleasure to be on the show and speak about IP issues, which are absolutely important at this stage. To start with this Abro's judgment, the matter has been referred to a larger bench. Now, what are the important questions that have been, sort of referred? In order to understand the basic premise that we understand in IP issues is that, some marks are registered, some marks are not registered. What happens when you get a registration? What kind of shield it provides you? And what happens in cases where a registered proprietor is sued? Whether injunction can be granted or not, because the bottom line in IP matters is the injunction. Usually what happens is when injunction is granted, that operates as a final, sort of judgment or injunction against a proprietor. Now, this case actually analyzes the issue of registered proprietor, whether injunction can be passed against them, can be, restraining orders can be passed or not. So in order to understand, we have to understand a little bit on the background of the matter. Now, Abros had filed a suit for infringement as well as passing off against another entity. The marks in questions were Abros and Nibros, right? So phonetically, I believe that was the case where phonetically they found to be identical or similar in nature. The court held that no case for infringement or passing off is made out because there was no similarity between the marks. And also the registration of the proprietor was in question. Therefore, the division bench basically made the submissions and they basically referred the matter to the larger bench, framing multiple issues. If you want, I can highlight those issues, but the heart of the issue, as you rightly pointed out in your opening note, was that whether injunction can be passed against a registered proprietor. Tarun, you're on mute.
Thank you, Kangan, for the opening explainer. Now we'll go to a round of comments by his panelists. I'll go to Senior Advocate Chandar Lal for his opening comment. Over to you, Mr. Lal.
Well, it's interesting because I think I started my practice with this issue of whether a registered proprietor could be restrained in the Whirlpool matter when I was assisting my father in collecting evidence for passing off. And there was a categoric finding that at least for passing off, registration had no bearing whatsoever. I thought the matter would have been closed, but I think having raised it again by Justice Hari Shankar, I think that shows the success of the IPD, where we are constantly, Whirlpool is almost 30 years old, and we are still alive with this issue of whether a registered proprietor can be restrained. Of course, Justice Hari Shankar does explain subsequently that he has not decided on passing off and it's squarely on infringement. And in his typical style, he does challenge the boundaries of IP law every time, applies a fresh look at it, So I think it's a very positive sort of a thing where issues which we think are settled again sort of come out in the open. So I don't think it should be an open issue, quite honestly. I think it's quite clear that a registered proprietor, in my opinion, can be restrained. And I don't think there's any impediment, and I'm happy to discuss that as we go into this program. But it's a good thing that a full bench can look into it and decide this issue once and for all. I think Justice Hari Shankar lays a lot of emphasis on a registered proprietor and gives him a lot of powers. I don't think the statute really gives the extent of power that this division bench has, the manner in which this division bench interprets a registered proprietor. I think it's a weaker, it's never been, and right from the Whirlpool days, it's never been a shield. A registration has always been a weapon rather than a shield. And I don't think it makes a very good shield. Yes, it is a weapon and you can attack others with an infringement action, but I don't think you can defend an infringement action or a passing off action by virtue of having a registration, though Section 28, 29, 30 do seem to suggest otherwise. But I'm happy to discuss that as we go deeper into this program. That's my opening remark. I think the full bench is likely to rule that a registered proprietor can be restrained in an infringement action, but that's time to tell. Tarun, you're on mute again.
Thank you, Mr. Lal, for your opening comment. I'll go to Senior Advocate Sanjay Jain for his opening comment.
See, in my view, the architecture of the Trademarks Act 1999 is very clear in this regard. There is a full-fledged mechanism which has been provided for removal of registered trademarks from the register. So therefore, in my view, automatically it follows that so long as the trademark exists on the register, the relief of infringement per se cannot be granted, and it will have to wait the outcome or the final outcome of the rectification proceedings. But that is a separate silo. Insofar as the interim injunction in exercise of the interlocutory powers of the court, that aspect is concerned, there is nothing which restrains the court, whether staying the suit or otherwise, even with it or without it, the court is empowered to consider a case for grant or refusal of interim injunction on the merits of the case. And though in my view, if it is a registered trademark pitted against a registered trademark, it should be only in exceptional circumstances as a last resort. In rarest of rare cases, maybe in pharmaceutical cases where human life cannot await the outcome of the commercial pursuits of the parties in rectification petition. But purely as a matter of law, purely as a question of law, Section 124(5) makes it absolutely clear that the court is empowered to go into this question and to decide one way or other. Now, as Chandar pointed out, on what principles? Because infringement, of course, would not be applicable as an interim aid. So therefore, the principles will have to be passing of principles. On the passing of principles, even if the passing of case has been pleaded, irrespective of whether passing of case has been pleaded or not, in the pleadings of that case, nothing prevents the court from applying the passing of principle and deciding such an application. That's
Point
my
very taken, Mr. Jain. I'll go to Senior Advocate Arvind Verma for his opening comment.
Yes, Tarun, thank you. And also, if I may just add my 2 bits, I entirely agree with Chandar. He's an encyclopedia in IP matters, and Mr. Jain. But I'll just add my 2 bits on this subject. In Abros versus Ashish Bansal, that is the reference of Justice Hari Shankar and Justice Ajay Dekpal. 13th May 2025 is the reference order. Now there, the plaintiff said that the defendant's mark is similar and amounts to infringement. But here, in that case, it's a very peculiar situation. And of course, I'll develop on that later. The defendant's mark is also registered. So now the situation, this is an unusual situation. And certainly, Justice Harishankar, I agree with Chandar. He gives a lot of credence to a defendant having a registered trademark. Now, registered trademark, as it's not a symbolic thing, it's a monopoly given by Parliament to use. It's an exclusive right to use your goods by a registration. So that is there. Now, but it's an unusual situation. So it is no longer a normal infringement suit or a passing of action where it is registered versus unregistered. Here it is registered versus registered. So this is definitely, I would say, in my most respectfully, it's a legal complication which the division bench thought. And since a coordinate bench of Rajkumar Prasad's, that's one of the questions which the division bench has posed, that whether the judgment given in Rajkumar Prasad's case was right or not. So now, because in my view, perhaps what perhaps passed through Justice Harishankar's mind, perhaps too, what is that Section 29 was not considered in Rajkumar Prasad. Now that aspect now, so therefore it is, I think it will be an interesting question before the larger bench. These are the questions which will be, I think they'll have to answer when posed from the bar, that this is there. Now the larger bench, to my mind, will have four short questions to deal with. That can you file an infringement suit against a registered proprietor? So now, can the court stop a registered proprietor from using their mark? Then, without following Section 124 steps, that is the structure. That is the structure. Section 124 defines the structure in these cases. Without resorting to that, can you grant an injunction? And also, which I have also pointed out, whether Rajkumar Prasad's judgment is right or wrong. So, to my mind, that will have to be seen by the larger bench step by step. Of course, it will be an interesting debate to watch.
Point.
So that is my opening.
Thank you for the opening comment, Senior Advocate Arvind Verma. I'll go to Advocate Arushi Singh for her opening comment.
Right. I think I'll have to agree with a little with everyone that has already spoken on the panel, because this is a thing that has to be referred to a larger bench to be decided. All arguments are not mutually exclusive. I feel they are somewhere interconnected. It is very important for the courts to follow the statute, as well as the courts to maintain the fact that a registered proprietor should be able to use his mark and should not be restrained. That is not unauthorized use by him. So we'll have to really see what the larger bench will be opining on all of these issues. The four that Mr. Verma has also spoken about.
Arushi, does allowing injunctions against registered marks undermine certainty in IP rights?
See, IP, the whole statute is, the purpose of the statute is to provide for rights to a statutory right holder, that is a trademark holder. A person goes through the whole process of filing for registration, the whole time period it takes for his mark to get registered, the financial bit of it that will be incurred by the proprietor to undergo that whole process before the trademarks registry. So denying him the right to use his particular goods or services for that mark that he has undergone this whole process, tedious process for, is also not fair. However, on the other hand, it will cause serious damage to his market reputation, his whole business prospects in the future. However, it is also important to see who is the prior user and the actual honest adopter.
Point very well taken. I'll go to Senior Advocate Chandralal. Are rectification proceedings in your view becoming a procedural bottleneck in trademark enforcement? You're on mute.
I said not at all. I think cancellation, removal, rectification are very integral part of a trademark statute. And the Act does provide for a rectification or removal under 47 and rectification under 57. And I think when we look at it, and Arushi mentioned about being unfair to a proprietor who's been through the rigors of the trademark office and having got a registration, no registration can be a final adjudication of rights. And the Supreme Court, right from Whirlpool onwards, had categorically said that trademark registration is an addition to what exists at common law in any case and provides an additional remedy rather than a shield to shield a defense action. I think what Justice Harishankar seems to have missed is there are only two places where, and I think we are very clear, and I agree with Sanjay, that there's no question of a final relief of infringement against a registered proprietor. So if at the trial stage you have not been able to invalidate a registration of a defendant, you're not going to succeed in a final injunctive suit. The question really is, what if there is a registration of a defendant? Justice Harishankar concludes that you can't even initiate an infringement suit. If you can't initiate, and with due respect to him, he says that if I don't know of the registration of the defendant and I file an infringement suit, is when 124 will get triggered and the defendant takes a 30 subsection 2 registration plea as a defense is when 124 gets triggered. That, in my view, may not be correct. First things first, there is only two places where the Act talks of interlocutory relief. That's 135 and 124. So it's a little strange that in today's day and age, there are judgments which say that you're supposed to search the register before you come to court. So I think you'll get a rap on your knuckle if a plaintiff today comes to court and says he couldn't even conduct an online search to find out that the defendant was a registered proprietor of the mark that you intended to. So in effect, if Abros is to stand, then there's no question of a registered proprietor being sued because there's no question of a plaintiff today with an online record not knowing that the defendant is a registered proprietor of a mark. Now, if you look at 124, and I think we've missed the point of 124.11, it says if any proceedings for rectification of the defendant's trademark are pending before the registrar or the High Court, stay the suit pending the final disposal. So that takes into account an already pending rectification proceeding against the defendant who I now sue, and I have knowledge of that pending rectification, or I have initiated that as the plaintiff. 124.1 gets triggered. So it's, I think, a little extreme to say that the plaintiff must not know of the defendant's registration and that's only when it will trigger. Then it's unworkable. And I think then we are making 124 osios. And I think Justice Pratibha Singh's judgment is the correct judgment that a registered proprietor can certainly be sued. And then also PM Diesel, the PM Diesel case also discusses this, and the Supreme Court in Patel Field Marshal has categorically said that even if a rectification petition is pending, the suit court is liable to look into the tenability of that rectification. So that is where I think the 124 connects a rectification to a suit. And then the Marico case, a division bench of the Delhi High Court says that a court granting injunction or not granting an injunction or an interlocutory court will look at the tenability of the registration and the strength of the registration, whether that's the plaintiff's registration or the defendant's registration. So surely we are not saying that if there is a weak registration of a plaintiff, he is entitled to an injunction under all circumstances, even if his trademark is liable to be invalidated for several reasons. And certainly we can't say that merely because a defendant has obtained registration owing to either faulty examination or subsequent acts of non-user, and it's a weak registration, but irrespective of the weak registration, 124.5 for interlocutory relief will not get triggered. So the Supreme Court in Patel Field Marshal establishes that link. And you have to see Patel Field Marshal in that context to say that if the Supreme Court is saying even if a rectification petition is pending, the suit court will look at the tenability of that rectification proceeding, then what is the purpose of looking at that tenability? What if the suit court finds that the defendant's registration is shaky on its feet and liable to be rectified, and there's a strong ground for rectification? Will the suit court stay the suit and refuse an injunction merely following Abros to say, since you are the registered proprietor, I'm holding my hands. My suit for infringement must fail because I knew of your registration before I sued you. So infringement suit 711 lies and passing off must proceed. Of course, on the practical front, it's rare to find a case only for infringement and not for infringement and passing off. So I think lots of cases will run through the passing off test. And the other aspect is the Supreme Court and Kaviraj Pandit saying that in any case, if the marks are similar, the passing off test and infringement tests are similar. So a plaintiff who's using his mark and also has a registration and can establish a passing off claim will succeed against a registered proprietor, perhaps on whirlpool passing off principles, and will not have to go through the rigors. But I still feel that 124 becomes otious if Abros is to stand as it does today, and the view of Justice Harishankar is to hold. And I don't believe, with due respect to the court, that that is the correct view.
Thank you. Thank you for sharing those insights into this issue. I want to ask Advocate Kangan Roda here that if you look at litigation strategy, then how will this reference affect litigation strategy for brands which are competing registered trademarks?
I believe, Tarun, in that case, we will have to look at rectifying what Mr. Jain also mentioned. Rectification clubbed with the passing of action. Probably that is the only remedy that we can kind of strategize going forward. I am sure Mr. Lal will agree to that strategy, because then in that case, in any case, infringement cannot lie, right? So as a first step, definitely, rectifying the trademark that has been registered and proving passing off, because in any case, we have seen that passing off action, time and again, even Supreme Court has categorically sort of stated and clarified the position in Sayyid Muhyiddin as well, that standalone passing of action can even lie against a registered proprietor, even if it is not infringement. So the whole idea of injuncting a false or a mala fide user of the mark still upholds, right? So in that case, I believe going the way of rectification clubbed with passing off is what my short answer to that would be.
And I might add that Justice Harishankar has also said that in Vaidya Rishi, subsequently clarifying that he's not ruled on passing off.
The infringement. Yeah,
Passing
right.
off will still lie. So the court
Exactly.
is clear that
Exactly. Yeah.
Point well taken. I'll go to Senior Advocate Sanjay Jain. Also want to ask him an additional question that what do you see the courts doing in this? Till trademark law towards a stronger statutory protection for registrants or greater judicial flexibility to prevent confusion?
In my view, there is no confusion in the current scenario. 124.5 is pretty much clear. And even if you divorce this entire issue with 124, there are other defenses available to the registered trademark owners. For instance, honest concurrent user. There may be a possibility of a defense under Section 30, subsection 2E, etc. So there is nothing in law which prevents a suit being instituted against a registered trademark in question. So the law doesn't prevent it. So in my view, there is no confusion per se. But as Chandar has mentioned and all other eminent panelists have pointed out, there is no harm if there is a greater clarity. And in any case, Delhi High Court has always been pioneer so far as IP issues are concerned in giving clarity to the whole nation and maybe to the whole world. So it may lead to a greater clarity, but it appears that some issues are sort of getting overlapped in this appreciation or understanding. Because suppose I am a registered trademark owner and there is another registered trademark owner, and I feel that I have a cause of action against that registered trademark owner. It is for that registered trademark owner to come and say that, look, here is my defense. So how can I preempt his defense? One. Two, the question of granting an interim order is always independent of and distinct from the ultimate outcome of the suit. So for that, there is already a regime, a complete architecture given in the Trademark Act. There is also a possibility or an availment of a remedy which has been given to the defendant. He can say that, look, the plaintiff's trademark has been brought in illegally. I am raising the validity issue. So an issue be cast, suit be stayed, etc. So therefore, for every different aspect, the Trademark Act provides a regime, and it is a robust regime. I do not think that it requires any reintroduction of or reinfusion of any new blood, etc. But there is always a scope for greater clarity, which may be resorted to. And so far as the jurisprudence with regard to the trademark is concerned, the courts have always believed that whosoever is the owner of the intellectual property must be given the protection. So now the question is, as often it happens in closely fought cases, as to who is more right, because both the sides claim that they are right. So all the conflict in this world is not between right and wrong. The conflict in this world is between right and right. The question is who is more right, and this is what courts decide.
I thought you were just beginning to get a bit of mythology into this discussion today. I'll go
I
to
thought we started discussing politics.
So I'll go to Senior Advocate Arvind Verma. No, you and Arushi, I want to sort of reflect on this. Is a Trademark Act structured to prevent courts from injecting registered marks, or does equity will sort of allow intervention despite the registration?
So here, Tarun, if Arushi, you want to speak first?
That's all right. Please, you continue. I'll add to what you have to say.
So trademark registration, to my mind, subject to whatever the other eminent panelists say, is supposed to give commercial certainty, Tarun.
Okay.
Now, if every registered proprietor can be immediately restrained because of an infringement or a passing of action, somebody files a suit that your registration is invalid, then it certainly loses practical value. I'm just talking more as a commercial and a civil lawyer than a IP lawyer. Registration loses practical value. But on the other hand, if the courts never grant an injunction until rectification ends, Mr. Jain mentioned in this earlier opening comments, now dishonest traders may misuse registration. Now there are two things to it. So the law has to balance. Law, I think our High Court compared to Madras and Calcutta, that wherever, to my limited knowledge, the IP jurisdiction extends, or the more litigious high courts where the IP, of course, Delhi High Court is the most. So the law has to balance two things: protection of statutory rights and protection of consumers and fair competition. Also, the fact that this, so far as this is concerned, one is that you send the matter immediately for rectification if they are registered versus unregistered. Registration, registered plaintiff and a registered defendant, passing off action or an infringement action, immediately you send it for rectification. But it may take years. Rectification may take years. So Section 124(5), what Mr. Jain said, immediately comes to the rescue. There the court can grant interlocutory powers, has the power to grant interlocutory reliefs. So to my mind, whatever perhaps our High Court has been a pioneer in doing this, that if invalidation of the registration is prima facie held, you grant an injunction, frame an issue, send it for rectification. But while the suit is pending, you grant an injunction, the suit remains there. So the rectification may take years. So it is once you're prima facie satisfied that registration is invalid, so then an injunction should be granted under 124(5) is meant for that. The law is, the Trademark Act is not silent on it. So you do that, frame an issue. That should be the correct course, and then send the matter for rectification. To my mind, that is the way out.
Point very well taken. I'll go to Advocate Arushi Singh for her opinion.
Yes, I think I would I am inclined towards what Chandra sir has also said right now, that if an injunction is not granted, what is the whole purpose of someone filing a suit? There is no, the law is clear with respect to passing off, the suit will move on. However, with respect to infringement, the suit has to be stayed. This is also what was held in Amrish Agarwal, if you would remember, that is, a full bench has already sort of decided on this particular aspect. However, with respect to two trademarks that are registered, is what really needs clarification from a larger bench. I feel that there should be this possibility of deciding the whole aspect of whether at all an injunction should be granted, because if a like Sir said, the tenability of the registered proprietor, whether the mark demonstrates all the aspects of being infringing to another person's mark, and then the final decision should be made. And also, as Arvind Sir said, that this matter should very quickly be referred to for rectification proceedings, and there should be a very strict timeline under which that should be decided.
Point very well taken.
If I
Yes,
could ask, I want to ask all the panelists a question, if I could. I'm a plaintiff. I'm aware of a defendant having a registered trademark, and I'm a registered proprietor, and I want to initiate a suit for infringement against this party. Does the suit lie or not? I have knowledge of the registration. Does the suit lie against that defendant for infringement per se, no passing off? That's the question that Justice Harishankar has raised. And his answer is no, the suit does not lie. I'm querying whether that is possible. Let's get clarity on that. I am firmly of the opinion that it lies and injunctive relief is possible purely on infringement, with, of course, the
It lies
facts.
absolutely. The suit lies. There is no doubt about it. There is no embargo in the institution of suit or the maintainability or sustainability of the suit.
That's one of the aspects that's been referred, whether the suit itself lies. And the view in Abros is that if you have knowledge of the defendant's registration, then the suit will be barred under one. You can't file under 28, 29, and 30. If you don't have knowledge and then a 32E defense is taken, then of course 124 gets triggered. So that is Justice Harishankar's Abros view.
No, I tend to agree with Mr. Lal and Mr. Jain both. That certainly there's no embargo on the suit, and your knowledge of it. What I think Chandar, you're laying emphasis on the knowledge.
Correct.
Knowledge, registered plaintiff filing for an infringement suit
Against
with knowledge of the registration. So certainly I've come with the 10% up. That's what you're saying.
No, knowledge of the defendant's registration.
Yes. That's what I've come with the plus 10%. So certainly it is there. But also it has to be weighed on a chessboard. I just feel weighed on a chessboard. Every registered trademark, every registered defendant, if an injunction. So certainly the law will take its course. I definitely tend to.
In today's time, how can you claim that you don't know about it? I mean, everything is in public domain. Claiming or pretending that I didn't know about it is giving impetus to cantankerous kind of pleadings.
There are at least 3 decisions. I think it started with Justice Badar Ahmed's view that you have to conduct a search before you come to court. So you must know of the defendant's registration. Kangan, what's your view?
That's why the courts are insisting on a cease and desist pre-action.
Correct.
Cease and desist pre-action.
Correct. So Kangan, Arushi, what's your view? Does the suit lie or not?
If I read the Act 28.3, I stand corrected, clearly operates as a bar.
It's a bar.
It's a bar. It says that a suit cannot lie.
Statute doesn't provide for it. However,
Arushi, you support that? No, should not. Does it or does it not? According to you.
So it does not. It always goes as infringement and passing off.
So thankfully, all 3 senior advocates are differing from your view.
If I can add here, a suit can lie, it will be maintainable. Again, what Mr. Jain pointed out, it's not about the maintainability. It lays down the fundamentals of infringement claims.
I want maintainability. Abros holds it's not maintainable.
That's right.
Are you in agreement with that? You are.
Yes.
She's representing the registered proprietor, registry, right? She obviously wants that strength, the power to the registrar.
In fact, she has a biased view in a lighter vein because she represents the
yes, she wants the registration, but then she's blunting the poor plaintiff's registration.
As an aside, before Chandarlal takes up my practice, I think I should we should get on with the show. But I think we're almost out of time. I would like to thank Senior Advocate Chandarlal, Senior Advocate Sanjay Jain, Senior Advocate Arvind Verma, Advocate Kangan Roda, Advocate Arushi Singh for making time for such an important issue. Of course, we will discuss this once again when the larger bench takes it up, as and when. Doesn't look like it's going to happen soon, but whenever it happens. But at least we brought this to the public domain. I think let there be much more discussions on this. Looking forward to discuss this in future when the bench starts hearing it. Appreciate you joining us. Thank you so very much.
Thank you very much, Arun.
Thank
Thank you.
Thank you all.
Thank you.